You bought it. It's broken. But they say no refunds. Here is why they are lying to you. And I don't mean that loosely. I mean, there are specific federal and state laws in the United States that give you the right to a refund in situations where a store, a brand, a website confidently, professionally, with a straight face will tell you that you have no options. They will show you a sign. They will point to a policy. They will say, sorry, all sales are final, and most people just leave. They walk out with a broken product, an empty wallet, and the quiet frustration of feeling like they got cheated but not knowing what to do about it. This video is for those people. And before we get into it, I want to be upfront. I'm not an attorney or legal advisor, and nothing in this video is legal advice. Laws vary by state and by situation. And if you're dealing with a real dispute, you should consult a qualified lawyer who knows your specific circumstances. What I can do is show you the landscape, the actual legal framework, so you stop walking away from money that might legally belong to you. Now, let's talk about what no refund actually means under the law, because there's a massive difference between what a store is allowed to say and what the law is actually required to protect. Here's the first thing that breaks most people's brains when they hear it. In the United States, there is no federal law that requires a store to accept returns or issue refunds for purchases that simply didn't meet your expectations. If you bought a shirt, wore it once, decided you didn't like the color anymore, and tried to return it, a store can legally say no. Their no returns sign is valid in that situation. That part is real. But here's where it flips completely. And this is where most people don't realize the game changes entirely. The moment a product is defective, meaning it doesn't work the way it's supposed to, it breaks under normal use, or it was falsely described to you at the point of sale, you are no longer just dealing with a store's return policy. You are now in the territory of something called implied warranty law. And implied warranty law doesn't care what the sign on the register says. Let that land for a second. An implied warranty is a legal protection that exists automatically. You don't negotiate it. The seller doesn't offer it. It comes attached to almost every product sold in the United States by default, under something called the Uniform Commercial Code, a set of commercial laws that most states have adopted in some form. The specific protection that matters here is called the implied warranty of merchantability. What does that mean in plain English? It means that when you buy a product, the law assumes without anything written down or agreed to that the product will actually do what that type of product is supposed to do. A blender is supposed to blend. A phone charger is supposed to charge a phone. Headphones are supposed to produce sound. If the product fails to perform its basic function under normal use, the seller has breached the implied warranty of merchantability. And when that happens, you generally have legal grounds to demand a remedy, which could be a repair, a replacement, or yes, a refund. Now, can sellers disclaim implied warranties? Sometimes. There are legal ways to do it, typically through written language that explicitly says the product is sold as is. You'll sometimes see this at thrift stores, auction sales, or private party transactions. But in a standard retail environment, especially when a product is brand new, sellers can't just slap up a no refunds sign and wash their hands of a defective product. The implied warranty often still applies. And if they've tried to disclaim it improperly, that disclaimer may not even be enforceable.
Let's
but
break
wait,
down this complex
because
concept.
it gets even more layered than that. And this is the part that most people who've been denied a refund have never heard. There's a federal law called the Magnuson-Moss Warranty Act. It was passed by Congress and signed into law in 1975, and it governs written warranties on consumer products. Here's what it does that matters to you. If a company offers you a written warranty, meaning they put something in writing about the quality or performance of their product, that warranty is now subject to federal law. And under that law, they cannot disclaim the implied warranty of merchantability entirely. They can limit it, but they cannot eliminate it. This means that the warranty card in the box, the warranty page on the company's website, the 1-year limited warranty that came with your appliance the moment that document exists. Federal law steps in and says your implied warranty protections are still alive. They can't just take them away. So when a company tells you their product has a 1-year warranty, but then also refuses to honor it when something breaks in month 2, that's not just bad customer service. Depending on the specifics, that could be a violation of federal law. Let's talk about the state level now, Because here is where it gets genuinely powerful. Individual states have their own consumer protection laws, and many of them go significantly further than federal minimums. Most states have what are called unfair and deceptive acts and practices statutes, often called UDAP laws. These laws prohibit businesses from engaging in deceptive trade practices, misrepresenting products, making false claims, and in many cases using policies that unfairly harm consumers. Here's why this matters when you're denied a refund. If a store tells you a product has a capability it doesn't have, and you buy it based on that claim, and then the product fails, that misrepresentation can be a UDAP violation, not just a dispute, an actual violation of state consumer protection law. And in many states, UDAP violations entitle consumers to remedies that go beyond just the refund, including in some cases double or triple damages and attorney's fees. Courts in states like California, Massachusetts, New York, and many others have robust consumer protection systems built precisely for situations like this. So what do you actually do when you're denied a refund you believe you're entitled to? First, stay calm and get everything in writing. Ask the store to put their denial in writing if possible, or document it yourself immediately after. Date, time, what you were told, who told you. Second, escalate internally. Ask for a manager. Ask for a district manager contact. Ask for corporate customer service. Many frontline retail employees are simply enforcing a script. The person above them often has more flexibility and more concern about the legal exposure that comes with wrongfully denying a warranty claim. Third, use your credit card dispute process if the purchase was made on a credit card. This is often the fastest resolution. Fourth, file a complaint with your state attorney general's Consumer Protection Office and with the Better Business Bureau. Neither of these is a lawsuit, but both create formal records, and in many cases, generate real responses from businesses. Fifth, for purchases under a certain dollar amount, typically a few $1,000s depending on your state, small claims court is a real option that doesn't require a lawyer. The filing fee is usually minimal. The process is designed to be navigable by regular people, and the presence of a small claims filing, where a business would have to appear and defend a refund denial, has a remarkable ability to resolve disputes quickly. Here's the thing I want you to carry away from this video. The no refunds sign exists because it works. It works because most people don't know that consumer protection law exists at multiple levels: federal law, state law, credit card protections, warranty law, all layered on top of each other. The businesses that post those signs are counting on you not knowing that. They're counting on the embarrassment and exhaustion of fighting back being more powerful than your desire to get your money. And for most people, in most situations, they're right. But now you know the sign doesn't tell the whole story. You know the implied warranty of merchantability exists, whether a store acknowledges it or not. You know the Magnuson-Moss warranty act means a written warranty can't fully strip your protections. You know your state has consumer protection laws designed specifically for situations like this. You know your credit card may be the fastest tool you have. And you know that small claims court is a real, accessible option that costs very little and signals to businesses that you're serious. You bought it. It's broken. And no, that sign doesn't change what the law says. This video is for educational and informational purposes only. I am not a lawyer or legal advisor. Laws vary significantly by state and by the specific circumstances of your situation.